Good evening. A longtime civil libertarian and author of 37 books, Alan Dershowitz has been called one of the most prominent and consistent defenders of civil liberties in America by Politico. In his latest book, The Case Against Impeaching Trump, he seeks to reorient the debate over impeachment to the same standard that he has continued to uphold for decades, the law of the United States of America as established by the Constitution. Professor Dershowitz is joined in conversation tonight with Josh Barrow, senior editor at Business Insider and host of KCRW's Left, Right, and Center and All the President's Lawyers. Without further ado, please join me in welcoming Alan Dershowitz and Josh Barrow.
Hi, everybody. Thanks for coming.
Hi, everybody. Thanks for coming. And Alan, thank you for coming all the way from the vineyard for us.
Sure.
We certainly appreciate it. I know that you had to leave the island under cover of darkness in a rowboat because you've been banned from the ferry. So that really shows a high level of dedication.
But I did create a new cover for my book, only for the vineyard. It's a brown paper cover, the kind we used to use as kids when we were reading dirty books. So the vineyarders can actually read the book on the beach without anybody knowing what they're reading. So
always innovating. I think at the end a little bit we'll get into people being mad at you and whether it's reasonable for people to be mad at you.
You're talking about my children and grandchildren now?
Mostly. Yeah. But first I want to talk about the book and the legal questions within the book, because I think that sometimes gets a little bit lost in these public conversations, and I think it's a very interesting book with an interesting argument. I want to start with the title. The case against impeaching Trump, because I feel like this feels a little bit premature to me in the same way that the cases for impeaching Trump feel premature.
I agree completely. My preferred title would have been The Constitutional Case Regarding Impeachment. That's really what it's about. But titles are designed to be provocative, and my publishers wanted Trump in the title. They didn't want constitutional in the title. And where are my publishers? Okay. And probably nobody would have bought it if they had my title. But this is not a brief for Donald Trump at all. In fact, if Donald Trump were to commit an impeachable offense, I'd be the first one calling for his impeachment. The argument is essentially that before anybody can be impeached and removed under the Constitution, you have to have an actual crime, whether it be treason or bribery or other high crimes and misdemeanors. But you can't impeach a president because you don't like his policies, because you don't like the fact that he, quote, colluded, even if there were evidence, with Russia. That's not a crime. Or fired Comey, or did other things. Look, there are so many things that this president did that I thoroughly disapprove of. I am against his immigration policy. I am against his separation of families. I am against his policies regarding abortion. I am against his tax policies. I'm against his health policies. And I'm even against his opposition to women breastfeeding their children. The latest crazy thing this administration did is opposing international policy. So don't try to get me to defend Donald Trump.
I think we
I'm
can
not
stipulate
that.
that this is not a political defense of Donald Trump. I want to. So would you agree that there are basically I see two really key claims in this book.
Right.
One is that impeachment has to be for a crime.
Right.
You reject this idea that Congress gets to decide to impeach over whatever it wishes to impeach for. That it has to be a literal crime.
Clearly, that's right.
And then the second claim is not that it will never be discovered that Donald Trump has committed a crime, but that the prominent things that people discuss, this idea that he has obstructed justice by firing James Comey or by asking James Comey to go easy on Michael Flynn or by raising the possibility that he might pardon people, that those things are not crimes, and that the things that are described as Russia collusion are not crimes by him, even though other people, such as people who hacked DNC email servers, committed crimes. crimes, that basically the big things that people tend to talk about when they talk about impeaching Trump, your contention is that those things are not crimes.
You got it absolutely perfectly. I wish you were reviewing the book, and I wish you lived on Martha's Vineyard, because if you ask my friends what this book's about, they would have a completely different point of view. And I think the first 28 pages lays it out completely and very clearly. And both of those positions are contentious. The vast number of scholars completely disagree with me. In fact, in 1986, I disagreed with myself. I wrote that impeachment was, I thought, because that was the common wisdom at the time, a broader criteria. Then when I went and did the research, I started doing it actually when Clinton was impeached. I actually advised President Clinton on his legal case when he was impeached. I did the research then, and I came to the conclusion that you require a crime. Now, everybody loved me for that. Everybody loved me when I said you need to have a crime to impeach President Clinton. But saying the same exact words about President Trump gets me in trouble. So in fact, I had my publisher do something interesting. They made an alternative cover to illustrate what I would have written had Hillary Clinton been elected president and had she been subject to impeachment. I would have written the same book, the same first half at least, about what we've talked about, but it would have been called The Case Against Impeaching Hillary Clinton.
How many different covers have you had made
so
for
far?
this book?
3.
Yeah.
And there are a few more in the works, but 3 are what we're working on now. Right?
Well, so actually, if we could, I'd like to take...
Actually 4, but we won't talk about that. Yeah, right. Okay.
I'd like to take the does impeachment require a crime part of the question first.
That's the most interesting and most challenging and most controversial.
And then we can get to Trump and his specific alleged wrongdoings. So you mentioned that this is a contentious question. One person who disagrees with you is your Harvard Law colleague, Cass Sunstein.
And Larry Tribe.
Yes.
And I think everybody else on the faculty.
Right.
But I'm used to that.
And so there have been several of these books. This is Sunstein's book. Tribe also has a book.
By the way, they're both terrific books. I really recommend them. Larry Tribe's book is readable and excellent, but wrong. Cass Sunstein's book is a little less readable, but very intellectual, but he doesn't really take firm positions on most things. It mostly lays out the analysis, but they're all worth reading.
But Sunstein does take some positions that are in direct opposition to you, particularly on this question of whether impeachment requires a crime. And so I want to ask you a little bit about his case, about why you can impeach someone over something that's not a literal crime, and explain why he's wrong. And so that to step back, the question here is about this constitutional provision, which says the president may be impeached for treason, bribery, and other high crimes and misdemeanors.
Right.
And then you might need to figure out what treason and bribery mean, but the most important thing is you need to figure out what other high crimes and misdemeanors means. And so your contention is that basically that, it means crimes.
Yeah.
What he says, and he goes back through the history starting in the 1600s in England when the standard first existed, and then the debates among the founders as they were debating what this clause in the Constitution regarding impeachment would say. And he says he's found quite a lot of examples where a misdemeanor is not a crime. I mean, you look in the English cases, and he says one example was an official who was impeached for losing a ship through neglect to bring it to mooring.
Right.
That if you entered an ignominious treaty, that could be a misdemeanor.
He's absolutely right.
And then in the American context, he quotes James Madison during the debates over ratifying the Constitution and some examples of things that he says a president might be impeached over. And so one is, if you need 2/3 of the Senate to ratify a treaty, but it's 2/3 of whoever's there. And so if the president pulled some chicanery where only a few local senators were in town, this made more sense back in 1790. And use that to approve a treaty that most of the states didn't actually like. He said, well, if the president were to commit anything so atrocious as to summon only a few states, he would be impeached and convicted, as a majority of states would be affected by his misdemeanor.
Well, it's so interesting because that's exactly what the Republicans did to deny us Merrick Garland. They pulled shenanigans, refused to allow the case to go forward, and there are some Democrats who are now thinking about the possibility of every Democrat leaving the halls of the Senate so that there would only be 50 senators present, which is not a quorum. You need 51. And that is just not an impeachable offense, and I'll tell you why. So what happened was the British, of course, had a broad definition of misdemeanor, and there was a debate about that. And some members of the drafting committee said we should have impeachment for malfunction of office or a range of other things. And it was rejected. It was rejected on the ground that we don't want the British system. We don't want the parliamentary system. We don't want the president to be able to be removed by the whim of Congress. That's the British system. That's every parliamentary system. In fact, we're almost the only country in the world that has a president that can't be removed if a majority of the legislatures want him removed. And so what they did is they introduced a two-tier system for impeachment. Number one, there has to be an actual crime, high crime or misdemeanor. And number two, that high crime or misdemeanor has to be of the kind that Madison and Hamilton talked about. And so that, I think, is the appropriate way of looking at it. But I don't even have to rely on that argument. When you look at a constitutional text, you never, ever get to the intent of the framers unless the words of the Constitution are ambiguous. And they're just not ambiguous. They say treason, bribery, or other high crimes and misdemeanors. And even Larry Tribe says that you can't look at the framers. Almost nobody thought about the impeachment provisions. There was no debate in any of the state legislatures. And you don't look at the intent of one or two people. You look at the intent or the understanding that the American people had at the time they ratified the Constitution. And Tribe says you really can't get much out of that at all, so you have to look at the text. And he has a very interesting example. He quotes Justice Scalia saying, you have to look, when you see 4 or 5 things together, you have to see what they have in common. So he cites the following example. Mickey Mantle, Sandy Koufax, Joe DiMaggio, and other great competitors. Okay, now, you wouldn't say Sam Walton is included on that list. Sam Walton's a great competitor, but the list is obviously limited to great athletic competitors. And what do the terms treason, bribery, and other high crimes and misdemeanors have in common? They're all crimes. And so you just look at the text of the Constitution itself. Then there's another principle of constitutional analysis. It's called lenity, leniency, lenity. It's a Roman, word. But it means that when you're construing a statute or a constitutional provision that has a punitive impact, you have to construe it in the narrowest possible way with all doubts resolved against a broad application. So let's assume hypothetically that Hamilton and Madison said what Cass Sunstein said. They didn't. What they said, in fact, was that's an additional element. Let's assume they said that. And let's assume the framers had in mind a broader provision. That's not what was ratified. What was ratified were the words of the Constitution. And when you look at the words and you apply the principle of lenity, you cannot conclude that the commission of a crime is not a prerequisite. Now, once you can prove the commission of a crime, you have to introduce other factors. Number one, it has to be a high crime. Number two, the political situation has to be such that the impeachment should go forward. The political element comes in after the high crimes and misdemeanors are decided. So that, for example, if you had a great president, Lincoln, and he had done something terrible, and it was an impeachable offense, and it was in the middle of the Civil War, the Senate probably would decide not to remove him, even though he was subject to removal on political grounds.
Right.
Now,
I mean, this is one thing you note in the book, that, that the Congress is entitled to impeach in certain circumstances.
Right.
It doesn't make them obligated.
But what they're not entitled to do is what they did when Lincoln was shot and replaced by Andrew Johnson. What they did is they just didn't like that SOB, and they were right not to like him. He did horrible things to America. He set back Reconstruction. He fired the Secretary of the War, even though Congress said you couldn't fire him without congressional approval. But he didn't commit a crime.
I want to ask you about the lenity thing, because this is part of a broader argument you make in the book that frankly doesn't make a great deal of sense to me, which is that you analogize this to a criminal proceeding and the president to a defendant and the rights of a defendant.
I don't analogize it. The Constitution does. It says he has to be convicted, tried. It uses words that are not ambiguous. It doesn't say he has to be found after a hearing. It says he has to be tried by the Senate and convicted based on 2/3 of a vote. What if it was only half? Could you remove him for that? No. How can you then remove him if he didn't satisfy the substantive criteria of committing a crime.
Well, so you say in here that it's especially important that we not ignore words in the Constitution that are there to protect the rights of individuals, even if those individuals are government officials who are being subjected to impeachment. I guess I don't understand what the rights are that are being implicated here, because the presidency is an office, it is a privilege, it's not a right. Impeachment specifically, you are not allowed to impose a judicial punishment and imprison someone because they've been impeached. You have to separately criminally try them. So it seems to me...
And doesn't that support my argument? When the Constitution says you can't imprison them, you can try them for the crime after they leave office, suggesting strongly that it has to be a crime.
No, I think it weakens your argument, because the reason to have this bias in favor of the rights of individuals is to avoid wrongfully imprisoning people, because we think that there's an enormous cost to getting, imposing judicial punishments on innocent people. And so since the impeachment process is designed so that the president cannot be subjected directly to a judicial punishment through it, I think it weakens that concern, and then you have to balance it against the concern, the rights of the public. It seems to me that the reason that you have this bias toward the defendant, innocent until proven guilty and a high standard of proof, is because the defendant is weak and the state is strong and you want to protect them. Here it seems to me that's flipped. Here the president is strong, the public is the one that is being protected by this provision. That's why we have the impeachment provision. So it's not clear to me why you would apply a parallel standard like you would from a criminal proceeding.
It's an interesting policy argument, but remember, under our Constitution as well, you can't take away people's rights, even if it's a property right or...
But what is the right here?
The right here is not to be impeached and removed. My God.
Where is that right established?
In the Constitution, because it makes it very hard to remove a president. Let me give you...
But that's not a right. That's an office.
It's an office, but the right to hold... There are two rights. The right to hold office. You have no right to hold office. You have to be elected. But once you're in office, the shame, the stigma, never has a president ever been removed. It is such a serious matter that you think, I would think at least, that you don't do it unless you've resolved all doubts in favor of the criteria haven't been met. Let me give you another example. Let's say we have a horrible president. A president who's committed all of these crimes. A president who has gone over to the Russians. A president who has helped arm the Russians. A president who has taken money, all of those things. And he's committed all of these horrible crimes. But because of the election, you only get 60% of the senators voting against him. Would anybody in the world suggest that you can remove that president with only 60% rather than 67 2/3%? No, because the Constitution says you can't. Or take another case. Assume the president commits treason, and there's such an overwhelming case against him. There was a person in the room while he was committing treason, and he recorded the conversation in which he was committing treason. Now, the Constitution requires 2 witnesses. Here you have 1 witness and an unchallengeable tape recording. And there isn't a constitutional scholar in the world who would say you could convict somebody of treason on that basis. Constitution says 2 witnesses. So let's assume you have the most brilliant guy in the world. He's 34 years old and he runs for president. Nobody would allow him to serve as president because the Constitution says 35 years old. You just can't tinker with constitutional language. Justice Scalia and Justice Brennan and others used to have this big fight. Is it a living Constitution? It's a dead Constitution. It's a foolish fight. Part of the Constitution is living, part of it's dead. The 35-year-old is dead. The part that says due process, equal protection, that's living, because you can't know what processes do unless you look at what's going on in the world. But you can't change other provisions. You know, we live a lot longer. When we had life tenure for judges, judges were appointed at 50 and lived till 55. The average judge served 5 years. Now we're appointing fetuses to the Supreme Court in the hope that they will serve for 90 years. Republicans don't care. Care so deeply about fetuses, they're appointing them. But nobody intended for these justices to serve 50 years, and yet they're gonna. But we have an amending process. That's the way you change the Constitution.
Well, so to your point about living and dead portions of the Constitution, there are certainly aspects of this that I think that there is no academic disagreement about. No one will say that you can convict in the Senate with less than 2/3. That provision is clear to people.
But why would say you can convict without convicting of treason, bribery, or other high crimes and misdemeanors.
I think the question is other high crimes and misdemeanors a living phrase or a dead phrase? I mean, as Sunstein lays out in his book, the idea of what a misdemeanor was changed over time. Why couldn't that continue to be the case?
Well, I don't think what's changed over time is the distinction between misdemeanors and felonies. That's what's changed. Today, nothing turns on whether it's a misdemeanor or a felony. In the old days, a lot turned on it. A felony meant you were tainted, your family lost its wealth. You could actually, under Blackstone, be convicted of, this sounds so strange, it sounds like an oxymoron, you could be convicted of a capital misdemeanor. He actually lists a number of cases where you could be executed for committing a misdemeanor. So misdemeanor suggested very strongly a certain type of crime. Now, you get Gerald Ford and Maxine Waters who say there's no criteria. Whatever the House impeaches for, if there's a majority, that's it. Whatever the Senate removes for, that's it. That surely is not the law. And even Tribe and Cass Sunstein admit that. Where the debate is whether or not you can define misdemeanor to include things that aren't criminal but that show an abuse of office. And I think the better reading of the Constitution is first you have to have a misdemeanor, the crime, then before you can impeach and remove, you also have to show that it's the... I'll give you an example from the life of one of the drafters. Many of you have seen the play Hamilton. I wrote about this before the play Hamilton. Alexander Hamilton had a terrible incident in his life. He was seduced by a woman while he was married. You all know that from the play. And it was all a setup. The husband of the woman who seduced him was in on it and went to him and extorted him to pay a lot of money. He acknowledged that. He actually wrote an essay which embarrassed his wife no end. But the reason he wanted to write the essay is because he was accused of using Treasury funds, he was Secretary of the Treasury, to pay the extortion. And he wrote the essay admitting the affair, admitting the payment, but categorically denying and disproving the fact that he paid Treasury funds. So he understood the distinction between high and low crimes. Having the affair and paying the extortion was a low crime. If he had used Treasury funds, it would be a high crime, and he could be impeached for it. And so he understood that distinction. And when I look at what he said during the debates, I certainly had that in mind. And I read his statements with that personal history in mind. And that helped to convince me that when he said it needs to be something that corrupts government, he said meant that in addition, not instead of, the requirement of crime. Let me make just one more brief point. Let's assume you're 100% right. Let's assume I'm 100% wrong. Why are people accusing me of not only being wrong, but being badly motivated? Motivated by money, motivated by greed. Somebody even said I was motivated because I wanted to be on the Supreme Court. I'm turning 80 in a month. I am not a fetus. I'm practically a corpse. I'm the opposite of a fetus.
If Trump's going to put someone your age on the court, he can put his sister on the court.
Right, and his sister was a terrific, terrific judge. There's only one problem. The Constitution, the statute, there's a statute, it's called the Robert Kennedy statute, precludes a president from appointing a close relative to positions. Now, it's a dispute about whether a judge counts as that. But I would just making the point as a joke. Why are people so insistent on questioning my motives? Have an argument with me. Maybe you've won this argument tonight. Maybe Cass Sunstein is right, Tribe is right. It's not a sin to put forth your best argument and be wrong.
I want to ask you one more thing about this issue of whether...
Thank you.
Of whether impeachment requires a crime, which is to say that you're saying you believe you have the right reading here, but different people have different readings. Who is the authority here who gets to decide? Because one of your key points in the book is that the Constitution binds all three branches of government.
Exactly. Boy, you really understand this.
But so then, if people in Congress have a good faith disagreement about whether you or Cass Sunstein are right in your reading of the Constitution, and they wish to impeach the president for something that they acknowledge is not a crime or might not be a crime,
right.
And they say, well, we're with Sunstein, we buy this, we think we're entitled to do this.
Great question.
That is most likely up to Congress, right?
Definitely.
Their own interpretation.
Definitely it's up to Congress, but we have three branches of government. You've left one out. So the president's impeached and removed without it being a crime because Congress believes you don't need a crime. The president believes you need a crime. He's the third branch of government. He says, I'm not going anywhere. You violated the Constitution. You didn't appropriately impeach and remove me. What are you going to do? Sue me. They're not going to bring the army because the president controls the army. Congress doesn't control the army. What are they going to do? Send gendarmes to remove him? At this point, the case goes to the United States Supreme Court. There's no other alternative. And so what I argue is to avoid that kind of constitutional crisis, Congress ought to narrowly read the impeachment criteria so as not to create a conflict with the executive branch. If it does, the legislative branch, the executive branch disagree, it's going to be up to the Supreme Court under Marbury versus Madison to decide who's right. And 2 prior justices have already said that if this kind of a conflict arises, Congress acts improperly, then the Supreme Court might very well intervene and decide the case. I lay all that out in the book as a possible scenario. I'm not advising President Trump, if he were to be impeached and removed, not to leave. I'm not advising him that. I'm just saying that is certainly a reasonable possibility when you have 3 branches of government and 2 of them disagree about the interpretation of the Constitution. In the end, that has to be decided by the Supreme Court.
Can I lay out why I think that would be very unlikely to end up being a problem?
Oh, of course it's unlikely.
Well, I mean, but an additional reason.
Right.
But
Yeah.
basically, as you know, you need 2/3 to convict in the Senate. So in any political circumstance in which the president has been convicted, even when there's a question about whether the thing was a crime, you'd have a bipartisan coalition of senators who have voted to convict him, which would only arise in a Nixon-type situation where the president's standing with the public has so degraded that members of his own party both feel compelled and feel politically free to go against him and convict him. And so in that circumstance, I think it would be very implausible that the Supreme Court would weigh in on the president's side. Because, I mean,
what would happen? Let's take the following.
The Supreme Court would side with Congress because, I mean, this is they would, and they wouldn't even have to reach the merits. They could say that this is not a justiciable question.
They could,
and
they might,
and that Congress decides these terms. And I mean, this is the John Roberts court. Roberts didn't want to overturn Obamacare because he feared the political blowback on the court. The idea that he would step into the middle of this dispute between the legislature and the executive.
He's not stepping in. He's presiding at the trial. Remember that to impeach and remove a president, only a president, the Chief Justice presides. He's not an empty suit. He's not just an empty robe. He's going to be sitting there making rulings. And if I were the president's lawyer, I'm not going to be the president's lawyer, but if I were the president's lawyer, the first motion I would make is, Mr. Chief Justice, you are the presiding judge here. This impeachment bill doesn't charge a crime. I hereby make a motion to dismiss the impeachment bill in front of you, Your Honor, a judge. And if the judge says, well, I'm just
There's
furniture.
no way.
I'm just furniture. I'm not really a judge here. I say, read the Constitution. They specifically made you preside. You have a job to do. What do judges do? Judges have to rule on motions to dismiss. Now, let's assume the judge does rule. And he says, you're right, I dismiss. And the Senate says, no. We're the Senate. We overrule you, and we're going to rule against you. These are all hypothetical possibilities. I'm a law professor, so I have a license to create hypotheticals. I've been doing it for 53 years. Look, I don't think any.
I believe it was Roberts who said the Senate is not just a jury; it's a court.
He said it's a court.
Wouldn't that seem to imply that it's up to the Senate to make those rulings ultimately because it is the court?
He said it's not just a jury.
Right.
It's a court.
It's a court.
But courts have also legal obligations, and if let's assume the Senate rules, the Senate votes because it has a slim majority. They vote to have 60%. They can't do that, even if the Senate wants to do it. Would you concede if the Senate removed somebody with 60% rather than 67%, it would go to the Supreme Court?
Yeah.
Okay.
Yes, I would.
So if you concede that, then it's only a matter of degree to concede that if there's no crime charged, then it would go to the Supreme Court. First of all, I don't think the Senate's ever going to charge anybody if it's not a crime. They charged Nixon with multiple crimes. Remember, they did not charge him with firing Archibald Cox. They did not charge George W. Bush when he fired Caspar Weinberger explicitly and very, very specifically with a corrupt motive to avoid Caspar Weinberger testifying against him. Nobody suggested that that's impeachable. If they were to impeach any president, I think Congress would go out of its way to find the crime. Now, the more interesting issue is what the evidentiary requirements are for a crime. Does it have to be proved beyond a reasonable doubt? What if they charged them with treason and they only had one witness? Does the two-witness rule apply in impeachment? I don't know the answer to that, and I say that very clearly in the book.
Well, so actually, I think this is a good time to turn and talk about the specific allegations against Donald Trump, because I think there's a key distinction to be drawn here about what would happen in an impeachment circumstance around Trump. Because you could imagine two things. One is you could imagine an article of impeachment against a president for an act that everyone concedes is not a crime. I mean, one that Sunstein lays out in his book is if the president just moves to London and stops doing his job for 6 months, Sunstein contends you could impeach the president for that even though it's not a criminal act.
That may be what Amendment 25 is about. If he leaves his job, or you might find that he has voluntarily left his job. I have another example. Let's see what you think about that. Russia invades Alaska and says, just like we took back Crimea, we're going to take back Russia. The deal that we made selling Russia for what, $25, selling Alaska, it was a bad deal. And it's invalid. I'm taking back Alaska. And the president doesn't do anything. Says, I think you're right. I think you're right. Alaska probably does legitimately belong to you. That would be the most horrible thing. He would never be elected again. His party would be utterly devastated. It's not an impeachable offense. It's not. The framers didn't think about that, and they didn't make it an impeachable offense. We can't rewrite the Constitution.
But that's not. This is not what he's going to be impeached over. And so where I'm going with this is that basically this is not
going to London either.
Right. No, but this is my point. The circumstance is not going to be Congress impeaches over something that Congress would agree up front is not a crime. Rather, it would be that Congress would impeach over something like seeking to obstruct justice through things like the firing of James Comey, and that there would be a dispute about whether that act was a crime or not.
And I lay that possibility out in the book, right?
And so, and this happens.
That's a hard question.
And this happens in criminal trials all the time, where the dispute is not did the defendant do X? It's was X an act
and
that,
when that happens,
met the definition of the crime.
Every legitimate civil libertarian, by which I mean to exclude the ACLU, every legitimate civil libertarian would say you cannot expand these statutes this way. You can't use obstruction of justice like an accordion to target people. When Nixon was impeached, I was on the national board of the ACLU. The ACLU watched very carefully. They were all in favor of impeaching the SOB, but they did not let the special prosecutor get away with anything. Today, the ACLU has made $130 million in contributions as a result of Trump being elected. They have abandoned civil liberties in favor of money and in favor of supporting certain basic left-wing and ideological positions. They have abandoned free speech on campus. They have now set a new priority. We're not sure we're going to defend free speech if it's offensive to minorities. The ACLU has lost its way. One of the reasons I have to be saying what I'm saying and losing friends and even losing support among family members is I am the only civil libertarian in the country who's prepared to make these arguments. Shame on the rest of the civil liberties community. Because if all of these arguments were being made about Hillary Clinton, she obstructed justice by destroying the tapes, by destroying her emails. She obstructed justice. She tried to get dirt. Every civil libertarian would be saying you can't expand these statutes. I have one test in my life. It's called the shoe on the other foot test. You have to ask yourself, if the shoe were on the other foot, where would you be? I honestly believe that almost everybody who was arguing for the impeachment of President Trump would be arguing against the impeachment of Hillary Clinton based on exactly the same facts and the same information. That is scandalous if that's true.
Well, so let's talk about the fact set and whether it would really constitute a stretching of the obstruction of justice statute.
I want to get to something first. That is, I want to apply the same standards. When you ask, would it be a stretching? Maybe it wouldn't be a stretching. But if civil libertarians thought the same facts would be a stretching as to Clinton, then they should be arguing the other way. even if they're wrong. That is, the ACLU is often wrong, but it always used to defend civil liberties, and it used to argue that you don't stretch obstruction
But the
statutes.
ACLU is not on trial.
Yes,
here.
it is.
Well,
that's the reason I wrote this book, because the ACLU has failed in its mission.
But your contention basically about the theoretical obstruction case around the president involves a number of official acts that he has undertaken or might undertake. Asking the FBI director if he can go easy on Mike Flynn, firing the FBI director, and making several indications that he did that at least in part because he was upset about the Russia investigation.
Assume all of that's true.
Right. So I guess your contention is basically that because these are constitutional powers of his, that it cannot be a criminal act?
That's right.
And
it cannot be. You need an actus reus and a mens rea for there to be a crime. Mm-hmm. It is utterly inconsistent to have as the actus reus, the act, a constitutionally authorized act, such as President Bush pardoning Caspar Weinberger. Let me give you some history. Thomas Jefferson was determined to convict Aaron Burr of treason, determined to do it. He told his attorney general, you must prosecute him. He told the Chief Justice of the United States, his third cousin, John Marshall, if you don't convict this guy, I'm going to get you impeached. He himself arranged for witnesses to come into the White House, and he made deals with witnesses personally, saying, if you're willing to testify against this guy, I'll give you a pardon. There was no such thing as immunity in those days. I'll give you a pardon. And if you're unwilling to testify against him, I'm going to tell my attorney general to go after you. Historically, we had a unitary executive. The president was in charge of administering justice. He didn't even have to appoint an attorney general. Attorney general's not in the Constitution. He doesn't have to appoint the attorney general. He can make himself attorney general. Benjamin Netanyahu appointed himself foreign minister. A president can appoint himself attorney general. He can appoint himself secretary of war. And if he does that, he can do all of these things. This is a terrible system. I'm totally against it. But it's the Constitution.
I don't understand why that would mean that an official act authorized by the Constitution couldn't be obstruction of justice. And I want to give a similar example.
Sure.
Let's suppose that I have a bunch of documents in my house.
Right.
They're my documents. They're my property. I'm legally entitled to do basically whatever I would like.
You're not
with
the president, though, right?
No, I'm not the president.
I'm not making the argument that all innocent acts can never be the basis. I'm saying that a constitutionally authorized act has a special status, and you can't go around probing the motives of presidents.
Why not?
Because if we can start probing the motives of presidents, let me tell you what you'll find. Why did President Obama do certain things? Well, because he's a patriot, because he's a partisan, a Democrat, because he wanted to write a book, because he wants to go down in history positively.
But this
because
isn't
he
about,
wanted to do favors for certain people. I'm talking about any president.
This isn't about probing the motives of presidents. This is about probing the motives of people. Obstruction of justice is a crime where motive is a key element. The person has to have a corrupt intent behind their act.
But that's not enough.
So right, but
the act has
it's an
to be
element.
illegal.
No, shredding my documents is not illegal. What makes it illegal is that I'm doing it for the corrupt purpose of interfering with an investigation.
But you have no right to shred documents. The act of shredding documents.
It's my right to property.
No. You have when there's a statute, there's a law that says if you have been subpoenaed or expect to be subpoenaed, it is a crime to shred the documents. If you just shred your documents, that's not a crime, even if you have a corrupt motive. You're absolutely right. If I go home today and I say, gee, it wouldn't be, I have some documents here. I'll give you a better example. Let's assume you go online and you access some dirty movies, and you just don't feel like people knowing that. So you go home and you figure out a way. I wouldn't even know how to do that. You get rid of it. If you do that by yourself, that's not a crime. But if you've been subpoenaed or expect to be subpoenaed by somebody who's charging you with child pornography or whatever, that's the crime. So the actual destruction, the act, is a crime. You cannot find for me a case anywhere in our history where a president has been tried, been prosecuted, been impeached for a constitutionally authorized act.
Well, we're
it
an
would
unusual
be breaking with precedent if we did it. And if we ever tried to do it, every liberal would be jumping up and down if it were a Democratic president and a liberal president. But we're trying to be creative now. The one thing you can't be as a criminal lawyer, as a prosecutor, you cannot be creative. It's against the Constitution to be a creative prosecutor. You have to be a boring, dull prosecutor who only looks at the statute books, looks at precedent, and only prosecutes people for clear crimes. You know, it was Lavrenti Beria who turned to Stalin and said, Mr. Stalin, you show me the man and I'll find you the crime. We don't ever want America to turn that way. The crime has to be there for all to see. There's a very famous case about that. Justice Holmes, back in 1920-something, there was a statute that said anybody who transports a vehicle, I think I said motor vehicle, a motor vehicle in interstate commerce is guilty of a crime. Very clear statute. Motor vehicle. It was written before airplanes. The first guy stole an airplane. First guy to steal an airplane transported across state line was prosecuted. He stole a vehicle. It had a motor. And he was prosecuted. And Holmes said, no, it's not clear enough. By motor vehicle, at the time it was written, what was contemplated was something that drives along the ground. If Congress wants to change that statute and apply it to airplanes, which of course they did the very next day, that's fine. But don't be creative, prosecutors.
The standard you've laid out here seems contradictory to me in that you have warned about how it is a problematic system to vest so much power personally in the president, and yet you're going out of your way to read in this idea that because the president has certain constitutional powers, that places him in what seems to be a unique position where we cannot read into his motives as an element of a crime when that may be done with all sorts of ordinary people all the time.
But it can't be done with senators, it can't be done with congressmen, it can't be judged with judges, and it can't be done with prosecutors. The Constitution gives senators and congressmen immunity. Are they above the law? No, it's the law which says that you can't question a senator.
There's a specific clause in the Constitution that says that, the speech or debate clause. What clause are you reading into?
The same clause that gives judges immunity. The judges said in a terrible case. Let me tell you about.
But not from impeachment. No, we're talking about an impeachment trial here.
No, I thought we were talking first about whether or not you could prosecute it, whether it's a crime. So
whether it's a crime because we're talking about your standard that it needs to be a crime in order for you to impeach.
So first we have to ask the question, is it a crime? Let me tell you about this case. So a corrupt judge somewhere in the South, a man who's his friend comes to him and says, my daughter is being sexually promiscuous. I think there may have been, I don't remember, but I think there may have been a racial element. She was white, maybe the man she was, quote, promiscuous with is black. And I am terrified that she's going to get pregnant. So what I want you to do, Judge, is I want us to get together and I want to come in and seek a permission from you to have her have an appendectomy. And she won't ever know that her tubes are being tied. So they brought the young woman in. She had a, quote, appendectomy. Her tubes were tied. She then meets this wonderful man, different guy, marries him. They can't have children. She goes to the doctor. She says, of course, your tubes have been tied. She sues the judge. She and her husband sue the judge. Can you imagine anything more horrible than a judge doing that? The United States Supreme Court, I think unanimously, rules that judges are immune.
But he could have been impeached for that act.
Could have been impeached only if there's a statute that says you can be impeached for non-criminal behavior. So if there were such a statute, he could be impeached. If this is it wasn't a federal judge, he was a state judge. Maybe the state law permits impeachment. Federally, he could not be impeached for that. No, he couldn't be impeached for that. It's not a crime.
It's battery.
Then why does he get immunity for it?
He has immunity from, it would have to be a crime for you to be immune from prosecution
battery.
for
He
it.
didn't touch the woman. You might make a stretched argument that it was a conspiracy.
I think if you arranged for somebody to get a surgery that they had not intended to have, you might be expected to be charged with a crime for having done so.
It certainly should be a crime, and it certainly should be a crime, and perhaps it is. The point is a very different one, though, and that is.
But I think this goes back to the president.
Every branch of government has immunity.
But not from impeachment. I mean, I agree with you that you couldn't criminally try the president for something like that while he sits.
Well, even that's very controversial.
I realize, but you could impeach him for an act like that.
Not if the Constitution says you can't. It sounds like if I were writing the Constitution. Well, okay.
I'm pretty sure that's a crime.
Okay, so
he has immunity from prosecution, but you can still impeach him.
No, I agree with you. I think if you have the president committing a crime, of course you're right about that. If the president Nixon is the perfect case. You couldn't prosecute Nixon for paying hush money, for telling his subordinates to lie to the FBI, for destroying evidence, and for doing all the things he did. You couldn't prosecute him for that because the president can't be prosecuted. But you could impeach him for that because it's a crime. So I agree with you. I concede that point. I'm not conceding it. I assert it. That's what I say in the book.
Right.
You can, as long as it's a crime. But the point I was making is that doesn't put the president above the law. It's the law that sets out these restrictions for senators, for congressmen. And you're right. All of them can be impeached if they committed a crime. They just can't be prosecuted, and they can't be impeached unless they've committed a crime.
I do want to talk a little bit, and I know we have talked a little bit about it, about your shunning on Martha's Vineyard, which it sounds like is not as severe as maybe it's been reported in the press.
Well, it was very simple. It just started by, I was just minding my own business, and everybody on the vineyard started telling me that there were a bunch of people, it turns out to be only a handful, that wouldn't attend any event that I was invited to, told the Film Society that they would cut off funding from the Film Society if they invited me, and a series of other things like that. So how do you respond to that? I wrote about it. I'm not embarrassed about it. I wrote about it. And mostly people on the vineyard were very critical of those who took that position. I think I've gotten invited to more dinners and more parties from Martha's Vineyard to Nantucket. And the end result is the few people have stayed away. It doesn't affect me at all. It affected my wife a little bit because she has a social circle, she has friends, and I would not win any popularity contests in Chilmark today. If I were writing the same book about Hillary Clinton, there'd be a statue to me on the middle of Lucy Vincent Beach.
I think that obviously there's a high, an unusually high level of political tension, but I think part of why people are having this reaction to you, and I'd like your reaction to this, is I think people kind of think you're being a troll.
What does a troll mean?
That you're doing this sort of for the sake of being contrarian. And
well, my whole life I've done things for the sake of being...
Well, exactly.
I think I'm a contrarian. That's what I do.
Yeah.
I'm a professor. I'm a teacher. I always take positions that other people won't take. I think I'm performing an extraordinarily valuable function by doing what the ACLU should be doing.
Well, but
I don't know why you call that a troll. Again, if the shoe were on the other foot and everybody were trying to push Hillary Clinton into jail, you wouldn't call me a troll if I took a contrarian position. So yes, contrarian, no troll.
But contrarianism isn't the principle. I mean, sometimes the reason everybody thinks something is not that there's like dumb groupthink that needs to be challenged. Sometimes they're just right about something.
So let them debate me, and if the people think they're right, I'll lose the debate. You may have won tonight's discussion. People may think you are right and I'm wrong.
This isn't a competition.
No. I'm saying, but people may think Tribe is right, Castine is right. Why is that a bad thing? For me to be stating a position, look, in class, I used to state positions that were outrageous just to get students thinking and talking. For example, students didn't know that I had been devoting my whole life to opposing the death penalty. In class, I defended the death penalty because I couldn't get students until Ted Cruz became a student of mine. Then it was easy. I didn't have to be the devil's advocate. I had the devil in my class himself. But before that, I taught a class on where does your morality come from. And I gave students essays written by Southerners during the pre-Civil War period that justified slavery, the most horrible thing imaginable. How can anybody justify slavery? But when you read Calhoun's essay, Justifying Slavery, it makes you think about it. And so I would give students that. In the end, it strengthened their positions against slavery, but I always presented contrarian views. I mean, that's what tenure is about. That's why you are given tenure at a university, to be able to express views that nobody else is willing to express. Do you acknowledge that it's important to have a debate about this issue, about whether or not a crime is required as a condition of impeachment? Is it important to have a debate? And if it is, nobody else was taking that position. And maybe in the end I'm wrong. I don't think so. I think I will prevail in the court of public opinion. But that's up to you folks, not me. But why do you call me a troll just because I'm stating a position? I believe in this position, by the way, deeply. I deeply believe in this position. It's the same position I've been taking for 50 years. I don't support President Trump. I'm not certainly acting on his behalf, by no means at all. He doesn't like the fact that I oppose his policies and oppose his Supreme Court, his way he approaches the Supreme Court. But I'm sticking to my principles. So I think troll, a little harsh.
I want to use the few minutes we have left to ask some questions that came from the audience. First, someone asked if you've considered summering in Nantucket. I don't know if that would improve matters.
I prefer to be among Democrats who hate me than Republicans who love me.
There's a question here that's basically about the role that an inspector general could conceivably play in investigating the president. And actually, it relates to something that you discuss in your book, which is that you argue that the attorney general is a misdesigned position.
It is.
It ought to be split into two. There ought to be an independent prosecutor that the president couldn't fire, or at least that there would be a strong norm against firing him, although a lot of good that did with the FBI director. In a circumstance,
if I could write the law, I would say it should be like England and Israel, where you have a director of public prosecution that is not under the control of the executive branch, totally independent, and then you have a minister of justice who's supposed to be loyal to the president, who's an advisor. We merge those two positions into something called attorney general, and it creates an inherent conflict of interest.
And so in a circumstance like that, would whatever Mueller is investigating be under the purview of that independent prosecutorial office, presumably?
No. What Mueller's investigation definitely would be, we would never need a special independent counsel because every counsel would be independent. So it would all, and my view is that even this investigation should have been done by the Southern District of New York, by the District of Columbia, by the District of Virginia. The difference between a special counsel and ordinary prosecutors, remember we have people who are prosecutors who have been prosecutors 30 years. They are totally nonpartisan. They are very good, very decent people. The difference is when they investigate somebody for a year and don't come up with anything, they've done their job. If you appoint a special counsel and you give him $30, $40 million and a staff of 30, and you tell him to investigate particular areas, and he comes up with nothing, he's a failure. And that's not the way the criminal justice system should operate. Now, Mueller is not going to come up with nothing. He will have some low-hanging fruit. He will get somebody like Manafort on a tax charge that goes back to 2005, and he'll squeeze him. As Judge Ellis, who wrote a very good opinion in the case, said, not only do they sometimes squeeze them to sing, but sometimes they even compose. They become creative about the stories. It's a problem. And you're going to get 10, 15, 20 people indicted, and they'll all plead guilty, because prosecutors can get anybody to plead guilty, and they can indict a ham sandwich. Anybody you want to prosecute will be prosecuted. But I think that in the end, we'll be convinced that Mueller was unnecessary. He'll probably end up writing a report. The report will not lead to an impeachment or removal. We will have spent a lot of money, a lot of public attention. Look, if he comes up with real crimes... Well, a number of people have already been indicted, and some of them have pled.
Yeah,
but those are low-hanging fruit. Those are...
I mean, Manafort was the manager of his campaign.
Yeah, but what is he indicted for? You can look...
Bank fraud and violations of the Foreign Agent Registration Act.
Right, and if you take 1,000 businessmen and probe them, you're going to find
You think Paul Manafort's activities were not unusually criminal in nature?
I think they were unusually criminal, and nobody would have ever found them unless they were looking to squeeze and get him. The same thing is true with Cohen. What you're going to get is half the people who are indicted are going to be indicted for crimes that were committed after they were investigated in order to cover up their investigation. Those are called criminogenic crimes. That is, crimes that are created by the very fact that you're going after them. They're crimes, to be sure, but that's not what a special counsel is supposed to be doing. If he ends up prosecuting Flynn and prosecuting Manafort and nobody really close to the president, it will be a failure. And so he's going to be inclined...
Close to the president.
Who?
Flynn and Manafort. Flynn was the national security advisor, and Manafort managed his campaign.
Look at Manafort. So how many people here believe in the presumption of innocence? Manafort is now in solitary confinement 23 hours a day without having been convicted of any crime. There's something he's not been convicted of any crime. He has been indicted. Indicted. You can indict a ham sandwich. And there are thousands, hundreds, tens of thousands of minority young people today in prison without having been convicted of any crime.
I want to ask
An indictment is enough to lock somebody up in Rikers. And if you don't think Rikers is punishment, go visit it someday. This is a scandal. How many people today are in jail before there's a conviction, without a conviction? There's something very wrong with that, whether it's Paul Manafort or whether it's a poor 20-year-old black kid who can't raise the bail.
I want to ask one last question. And this is we have an audience question about Judge Kavanaugh, and if he becomes Justice Kavanaugh, what decisions he might overturn or chip away at or cause. And I want to ask you specifically about one that relates to the matter in this book, which is Clinton versus Jones, which is the decision that required Bill Clinton to testify in the civil suit that Paula Jones had brought against him over sexual harassment. It's a successor to suits that similarly involved President Nixon. Do you think that, I think Kavanaugh's writing on this has been a little bit misinterpreted because he's argued for legislative changes around this. He hasn't specifically said whether he thinks those decisions were mistaken. But do you think that there's a grounds to say that Clinton versus Jones was wrong?
Absolutely. It's not even a close question.
So a president shouldn't have to testify before a grand jury?
I was totally opposed to Clinton versus Jones when it happened. Of course a president
What about the Nixon decisions?
Of course, no, that's different. Of course a president should have to testify in front in a deposition after he leaves office. The statute of limitations should be postponed. But if you start burdening a president with every civil suit that anybody can possibly bring, it seems to me that really imposes an extraordinarily difficult burden on the president. So if I had been a justice, I would have voted against the Jones case. But by the way,
that's a policy argument. What in the Constitution actually says?
There's nothing in the Constitution either way, and it wasn't decided on constitutional grounds. It was decided simply on the ground that there is no basis for excluding a president from a normal civil suit. So
I guess my question is, what's the basis? What's the legal basis for excluding the president?
The legal basis is you look at the job of the president, and courts have discretion in civil cases. Civil cases aren't a big deal. By the way, no civil case should ever be tried in court. Every civil case should be done by alternate dispute resolution. The court should be reserved for serious criminal cases. The way depositions work today, the way civil lawsuits work today, destroys our legal system. I know there are some probably litigators here who are saying, "Oh my God, you're taking away our business." But by the way, 99% of civil cases never get to court. They just it's foreplay without intercourse. It's all depositions. It's all preliminary. It's all that you never get to the climax. And I think a system can be improved considerably if we required. The Constitution doesn't permit it. I'm making a policy argument. But I don't think Kavanaugh was appointed because he's going to help the president. Kavanaugh takes a completely different view than I take on the criteria for impeachment. He says in one article that probably you can impeach for committing a dastardly act. Now, can you imagine what the criteria are for how many people in this room have committed a dastardly act at some point in their life? I mean, what does dastardly mean? And that's the level of discourse that we've had about impeachment, a dastardly act. So if the president was looking for somebody to protect him, he'd have been a hell of a lot better off appointing me, even though I'm 80, than appointing Kavanaugh, who has a mixed record. He said, after serving, by the way, on the Starr Commission, he learned he has experience, more experience than the 9 justices and the 9 prior justices. And he said if it was up to him, he'd have legislation that postponed, not made a president immune, but postponed all these legal proceedings until after the presidency is done. That seems to be in the spirit of the Constitution. But with Nixon, obviously, with impeachment, you can't postpone. With impeachment, the president must be subjected, and that's a cost you have to pay. It's a balance.
Well, on that note, in the Dershowitz for SCOTUS campaign, I want to thank all of you. I guess we're doing a signing.
Well, the next vacancy, I'll be 82, you know. Thank you.
Thanks, Al.
All right, thank you so much.